and you would be able to activate to activate your mic. And also to get interpretation, you will see a globe at the bottom of your screen. And if you click on that, you can get your interpretation in English or in French as you desire. For those of you in the room, you have the choice at the bottom of your screen of either floor, English or French. And for those in the room, you can use the earpiece on the desired channel. Remember that all comments should be made through the chair. I just have one comment to make, however, and that is that we have had a very tragic accident with an interpreter because the witnesses were not using the required mics. And I have been asked to ensure that everyone is using the mic that had been sent to them, or not the headset that had been sent to them by the clerk. So this is very important that we remember that, because we don't want to harm people at the other end. Now, and therefore, having said that, I'm going to say that I want the committee to know that all witnesses have completed the required connection tests in advance of the meeting and are using the required headsets. So we begin. Bill C-18, we have 3 witnesses today. And the first, of course, witness would be Sue Gardner as an individual, McConnell Professor of Practice, Max Bell School of Public Policy, McGill University. And then we have Econ 1, Hal Singer, Managing Director, is there by video conference. And we have Internet Society Canada Chapter, Philip Palmer, who is the president by video conference. And clerk, I don't see Mr. Palmer.
No, Dr. Fry, Mr. Palmer is in the room.
Is he in the room? Oh, I have him by video conference. I'm sorry. Okay, thank you very much. And so what we are going to do is we begin, and here's a drill. Each of the 3 speakers will have 5 minutes to present. I will yell a 30-second for you to be able to know that you have to wind up. And then we will be followed by a question and answer period, and we'll get into that a little bit later. So I'm going to begin with Ms. Gardner. Begin, Ms. Gardner, for 5 minutes. Thank you.
Thank you. Thank you. Thank you so much for inviting me to speak today. I was a journalist in Canada for 10 years, working in radio, television, and online. I used to run cbc.ca. I used to run the Wikimedia Foundation, which is the nonprofit that operates Wikipedia. And that makes me the only Canadian to have run a global top 10 internet property. Last year, I was the McConnell Professor of Practice at the Max Bell School of Public Policy at McGill University. And I am speaking here in a personal capacity based on my own knowledge and my own experiences. I think C-18 is a very bad bill for 3 reasons that I'm going to unpack for you. So first, C-18 misdiagnoses the nature of the problem. C-18 characterizes as unfairness that Google and Facebook have such a large share of the digital ad market. And that is a fundamental mischaracterization or misunderstanding. So if you imagine it's the 1920s, I make buggy whips and you make cars, and C-18 is the government saying that you need to give me money forever because nobody is buying my buggy whips. The journalism industry used to be profitable because buying ads in the news was the best way, or at least a very good way, to reach audiences. And that's less true today. Google and Facebook have created advertising tools that are way more efficient and more effective than the old ones, and that is why advertisers are using them. Google and Facebook out-innovated the business side of the news industry, and that is not a fairness issue, it's not a moral issue, it doesn't make them a villain. Ben Scott told you that the government is in effect refereeing a contest between big tech and big publishers, and he urged this committee to focus on the public interest instead, and I want to say the same. My second point is C-18 will not actually support quality journalism. So the former CRTC head, Conrad von Finkenstein, told you on Friday that if you want to subsidize news publishers, you can do it in a myriad of other ways. And he characterized this bill as unnecessarily complicated. I think he's right. If the government's goal is to support quality journalism, the Public Policy Forum laid out a very good path for how to do that. In 2017, the PPF released Shattered Mirror, its report on the crisis in the news industry, and it recommended that the government start collecting sales tax on foreign company ad sales in Canada, and that money be used to establish a journalism fund to be administered by a body independent of the government. That would support quality journalism. C18 may attempt to achieve the same goal, but it does it by trying to awkwardly kind of force Google and Facebook into the role of themselves directly funding journalism. And that is a really tough fit. Google and Facebook are private sector Silicon Valley mega corporations, and their job is to advance their own business interests. They don't have a mission to serve the people of Canada. We don't elect them, and they are not accountable to us. The government can try to give Google and Facebook very specific direction and stand over their shoulders and try to compel them to do what it wants, but that is not the simple way. The simple way is to take their money and make a fund. My third point, C18 will have significant negative unintended consequences, and I'm going to speak here mainly about the internet and internet users. So C18 will encourage the creation of clickbait and nonsense. C18 will create an incentive for Google and Facebook to back away from news. And finally, C18 will enshrine in law the idea that ordinary internet linking is taking value. And that puts us on a slippery slope. The internet was designed to be open and to grow organically. The ability to link freely, and not just link, but to share, to comment, to annotate, to build upon. That is at the heart of the internet's openness, and that is well understood. With C18, the government introduces friction to linking. That brings us closer to an internet that is fundamentally commercial, where what we see online is going to be determined by corporate deals. That kind of change happens extremely slowly. It's the accumulated effect of many decisions that at the time might not have seemed very consequential in that regard, but it is one step on that bad
30
road.
seconds.
I'm done. Thank you very much.
Oh, thank you very much, Ms. Gardner. And then I go to the next witness, who is Mr. Singer. Mr. Singer from Econ 1, you have 5 minutes.
Good morning, and thanks. Good morning, and thanks for having me. It's a privilege to speak to a Canadian audience, and I wish I could testify in person. On behalf of the News Media Alliance, a collection of news publishers, I've worked extensively on companion legislation to C18 in the United States called the Journalism Competition and Preservation Act, or JCPA, and I will speak to those efforts. The economics are the same. Among other protections for news publishers, the JCPA would grant an exemption to antitrust laws for news publishers so they can better coordinate their dealings with the tech giants. Before going any further, I want to be clear. Antitrust exemptions are rare, and that's a good thing. Powerful entities should not be immunized from antitrust scrutiny. In some limited circumstances, however, coordination among small suppliers when dealing with a large buyer is necessary to overcome a power imbalance that is causing input prices and unemployment to fall below competitive levels. This market failure is the basis for the current exemptions for farm cooperatives in particular and labor in general from the US antitrust laws. And it is the same basis for extending a new exemption to newspapers in their dealings with dominant internet platforms. That the word preservation appears in the US legislation is no accident. The news industry has incurred losses in advertising revenues every year since 2006, according to the Pew Research Center. The effect of shrinking advertising revenues, in part caused by underpayment from dominant platforms, is less cash flow to support journalists and a clear employment effect flowing from the exercise of monopsony power by the dominant platforms. US employment among newspaper employees fell from 71,000 in 2008 to 31,000 in 2020, according to Pew. And as a result of the deteriorating news media landscape, hundreds of local newspapers have been acquired or declared bankruptcy. Google and Facebook reframe newspaper articles in rich previews containing headlines, summaries, and photos. The platforms also curate newspaper content alongside advertisements. This reframing and curation decreases the likelihood of a user clicking on the article, thereby depriving news publishers of clicks while enriching the dominant tech platforms. This appropriation of newspaper content at zero access price also decreases newspaper subscriptions. And when the clicks on newspaper content eventually come from the platform's websites, the associated advertising revenues are taxed by the platforms at excessive take rates. Now, the best way to correct the exercise of monopoly power is for the government to permit the news publishers to coordinate their dealings with the digital platforms over payment terms and conditions. Given the massive power imbalance, collective bargaining by itself might not be sufficient to achieve competitive payments, in which case some structured bargaining among the parties, for example, mandatory arbitration with an enforcement mechanism, is needed as a backstop. Now, curiously, some traditional anti-monopoly groups have stated their resistance to granting countervailing bargaining power to newspapers in their dealings with dominant platforms. In a joint statement, the American Antitrust Institute, Public Knowledge, Consumer Reports, Consumer Federation of America argued that, quote, a new antitrust exemption will only hurt consumers, citizens, and businesses that are not invited to the negotiations that this exemption is supposed to facilitate, end quote. It bears noting that some of these groups depend on the dominant platforms for funding. Now, instead of the JCPA, these same detractors have called for greater enforcement of antitrust laws against Google or Facebook. But the conduct that is being challenged here, the mere exercise of monopoly power to achieve a reduced rate for newspaper content, is not a cognizable vertical restraint under antitrust law. Scraping, reframing, and curation and appropriation of value do not amount to violations of Section 2 of the U.S. Sherman Act. And unlike Europe, the United States does not have an abuse of dominance standard. Moreover, even if one could style something else the platforms are doing as a cognizable restraint, a successful antitrust lawsuit, say, against Google, would provide zero relief for publishers in their dealings with Facebook. And a successful antitrust lawsuit against Google or Facebook would require several years to adjudicate, and the appeals might not be resolved for nearly a decade. In the interim, newspapers would be left twisting in the wind. Given the newspaper's precarious financial state, it is not clear how long many newspapers could survive without an intervention today. The JCPA has undergone significant amendments. The current version wisely introduces baseball-style arbitration, guarantees that publishers of all viewpoints are eligible to participate in negotiations, and imposes a size limit, incorrectly in my view, to focus support on small and local outlets. My last point, a more recent amendment ensures that a significant share of the funds, 65%, collected pursuant to the JCPA would be allocated to news publishers based on their pro rata share of a newspaper's spending on journalists. In other words, newspapers that shed journalists would be punished under the allocation mechanism as their pro rata share of the global award would be reduced. Thank you for your time, and I'm happy to answer any questions.
Thank you very much, Mr. Singer. And now I go to the third witness, who is the Internet Society Canada. Mr. Palmer, please, for 5 minutes.
Thank you, Madam Chair. On behalf of the Internet Society Canada chapter, I would like to thank this committee for the opportunity to address this important subject. As a preliminary observation, the Internet Society supports initiatives to financially bolster news organizations as they transition to the Internet era. We believe that a broader levy applied to all social media platforms and search engines, and coupled with a truly independent body to apportion funding, would have been fairer and more reliable source of funding than the illusory bargaining scheme that is at the heart of C18. Neither C18 nor the Australian legislation on which it's based represents bargaining based on the value of news content to news intermediaries. The bargaining process is contrived, apparent rather than real. Having stripped news intermediaries of legal protections, it is designed, under threat of excessive monetary penalties, to coerce intermediaries to agree to compensate news businesses. It withdraws the exceptions and limitations of copyright law from digital news intermediaries while leaving those same rights in place for their competitors and for the news organizations themselves. The government is using its legislative power to force a handful of businesses that have successful advertising-based business models to compensate an industry whose advertising-based business models are failing. I would like to quickly make a few specific points. First, C18 imposes significant cost on making news content through hyperlinks available to the public. Hyperlinks are the quintessential means by which individuals and businesses seek and find news content and all other information online. By imposing a cost on news intermediaries for links to news content, C18 threatens the efficiency of news retrieval on the internet and the ability of Canadians to access news content. C18 will raise the cost, directly or indirectly, of accessing news content in Canada. Second, the definition of a digital news intermediary in Section 2.1 raises complex questions of constitutional fact and law. Facebook and Google, for instance, are likely not subject to federal regulatory authority. Third, the criteria in Section 6 by which a digital news intermediary must self-identify are vague and inappropriate. They are borrowed from concepts as different from each other as competition law and labor law. The legislation neither defines the relevant markets nor sets forth what the imbalance of bargaining power relates. We would urge the government to consider following the Australian model in this regard, which the minister designates the intermediary according to clearer, not perfect, criteria set out in Section 53E of the Australian Act. Fourth, Section 27 has a bifurcated definition of eligible news business. 27.1a refers to qualified Canadian news organizations, a definition for the purposes of the Income Tax Act that requires that an organization qualifies by meeting demanding criteria. As numerous interveners have pointed out, 27.1b qualifies organizations with no observable journalistic standards. Click farms and foreign agents should not be eligible news organizations. We note Section 52p of the Australian legislation as a better model in this regard. Fifth, Section 24 denies to news intermediaries any reliance on copyright exceptions and limitations. It should be deleted. It nullifies any market-based approach to the determination of the value of news content to digital intermediaries. And last, Section 51 incorporates from telecommunications law the concept of unjust discrimination and undue preference. It has no relevance to the functions of news intermediaries. This provision should be deleted. Section 52D of the Australian Act seems to address these issues with far greater clarity. Thank you very much, and I welcome your questions.
Thank you very much, Mr. Palmer. And now we'll go to the question side of the equation. And the first round of questions are for 6 minutes. Now, I would like to point out that includes the answer. So if you're going to be, please try to get in as many questions and answers as you can. Let's try and be as clear and quick as we can in terms of that. So the first person in the round of questioning would be for the Conservative Party, Mrs. Rachel Thomas. Mrs. Thomas. 6 minutes, please.
Thank you. Ms. Gardner, thank you for your opening remarks and for taking the time to be with us here today. My first question, I guess, just to set the record, is I'm just curious as to whether or not you have received any sort of sponsorship or monetary contribution from any of the platforms.
No, I have not. I'm a completely independent voice. I used to be on the CBC payroll until 2007, but since 2007, I have taken no money from anybody tangentially, potentially, definitely at all involved in C18.
Okay, thank you. In your opening remarks, you referred to Bill C18 creating what you termed a link tax. And you talked about how assigning value to certain links over others potentially changes the entirety of the internet and the way that it functions. You said that it lends to the potential commercialization of the internet. You said that this would be a gradual change, but make no mistake, it would in fact occur. Do you care to expand on that a little bit?
Sure, yeah, I can. So in my opinion, the debates about whether C18 literally constitutes a link tax are kind of hair-splitting. They're a little bit beside the point. The whole basis of the legislation is the notion that making available material or facilitating access to it is taking value from the party that made the thing. And that notion flies in the face of the entire internet, because the entire internet is built on the concept of linking, sharing, annotating, commenting, building on the work of others. And that is what makes the internet fantastic. There are limits to that. We do have copyright law, but there is no need, and it is not beneficial to take the position that linking or making available is taking value, because it's not. I know that people tend to dislike the phrase breaks the internet, and I dislike it too, because it always sounds like hyperbole, and I am not trying to say that if this bill becomes law, the internet is immediately different or immediately broken, but it is consistent with breaking the internet, and it is a step on the road to breaking the internet. I would like to urge the committee to take a long view on this. The internet is still quite young. It's going to be with us for a long time. And I think that actions that we take today that may seem small and of little consequence will shape it and will shape how it develops in ways that I think we could come to regret. And this is one of those ways.
Mm-hmm. Are you able to break that down a little bit more? So if a value is ascribed to links, news links in this case, it kind of opens the door for value to then be ascribed to other links, which then, yes, could lead to the commercialization of the internet. Right now within television, we have cable packages, which of course people are moving away from because they're wanting, more choice, and so they're going towards other options. But if the internet goes down this path where you're ascribing value to certain links, could it eventually go down a slippery slope of landing us in a place where essentially you are having to pay for a package of certain links that you have access to, but maybe you don't have access to other links? Like, I guess I'm just trying to wrap my head around where does this eventually take us in terms of commercialization of the internet and giving monetary value to links?
Right, and I think what it does is it creates the condition in which it could be, as you say, applied to other forms of information, other forms of knowledge. I don't know that it would go down a cable television kind of road where you'd be buying, consumers would be buying packages. When I think about the commercialization, what I think more about is the idea that the internet, what is shown to you, what is given to you, is fueled by commercial deals and money changing hands in backroom corporate decision making that you don't know about, right? And so what you would be seeing would be commercially motivated, and it might be for good, it might be not for good. You wouldn't have any control over it. Whereas today, and certainly in the origins of the internet, things were not commercially motivated at all in the beginning, right? And we are on a road where potentially that changes. And I do think that breaks a lot of what is special about the internet.
Okay. Thank you. One of the things that the minister has claimed with this legislation is that it's based on, quote, market-based solutions. But the bill would actually ensure that the CRTC or the government intervenes significantly within the sphere of news and the bargaining process that would take place between intermediaries. And so I guess I'm just wondering if you can comment on the consequences of this being the case.
I feel like in some ways this bill is the worst of both worlds, right? I think the minister has said that he doesn't want to be in the middle between the news organizations and the platforms. But I think the truth is, if the government has policy objectives, it is in the middle. You kind of can't escape being in the middle. And so this is trying to do it, like I said, in a way in which it's kind of trying to force the platforms to play a funder role and to sort of give them criteria and things that they need to ensure happen. But that's not the correct role for a private sector entity, right? If you're trying to make policy, if you're trying to make
31 seconds.
If you're trying to make quality journalism available to Canadians, there are more straightforward ways to do that than trying to do it in this way where you're intervening in the market, but from a sideways kind of perspective. I'm not sure that was very articulate. I hope it helps.
Okay, thank you so much.
Thank you, Ms. Thomas. So I think you have ended your time, and I'm going to move now to the Liberals, to Lisa Hepner. Lisa, 6 minutes, please.
Thank you, Chair, and through you, I would like to direct my questions to Mr. Singer, who is an economist, and I'm hoping you can pick up our conversation. On Friday, we heard from Facebook that news actually doesn't have value to that platform. The opposite is true, and that news publishers should be paying Facebook for the privilege of carrying their news. I'm wondering what you think of this argument in your perspective as an economist.
Thank you. Yeah, I don't give much stock to it. And in fact, I've studied the issue through surveys as to how much value is being created by news publishers collectively to the individual platforms. And the answer comes out to something in the billions of dollars, at least in the United States. It's probably similar in Canada as well. There is some value returned in kind, but remember, that's only when the user actually clicks on the links and follows back through. And even then, the news publisher is going to be subjected to some super competitive take rate or tax on those revenues. So, but look, the point is that when we get to an arbitration, the news publisher collective is going to be able to put forward a study, potentially surveys, that are going to show how much value is being appropriated by the platforms from the news publishers. And Google and Facebook are going to get to hire their own economists, and she or he is going to put forward a counter study. And at that point, the arbitrator will have to decide whose estimate of the valuation being generated by the news publishers is fairest of them all. What's the fair market value that would emerge in a voluntary negotiation absent the power imbalance, right? That's what we're trying to get at here. The market forces are giving us a zero access fee. That's what the market has determined. And that's because Google and Facebook are just too big in this negotiation. The question is, what would be the competitive rate for this access? And you'll only find out through this arbitration process.
Thank you. And we've seen Facebook play with their news algorithms over the years. In 2020, during the U.S. presidential election, Facebook tweaked the algorithm to prioritize authoritative news over less credible news. And then a couple years earlier, in 2018, the algorithm was tweaked the other way to favor emotionally engaging content, inflammatory opinion, and disinformation over straight-up news reporting. What are your thoughts on this?
Well, I think this is a serious issue, but I think it might fall outside of the questions that we're talking about today, which is how do we come up with a structure in which we can solve a market failure and compensate news publishers for the value that they're creating for the platforms. I do think the issue that you raise is an important one, but I think it should be dealt with in a separate proceeding, respectfully, if that would be okay.
I think it's important because Facebook is deliberately changing the behavior and consumption of its users. But I get that you're not comfortable answering that question, so I'll move on and go back to the value that you attributed. You said in the billions, and I think in the UK, economists have also tallied up what they think news value is on these platforms, 1.2 billion to 1.6 billion Canadian dollars at Google and Facebook. And a high proportion of search activity on these platforms is for news. Can you comment on that?
That's right, and that's the question that we're trying to get at exactly in these valuation studies is what brought you there? What are you doing in the search? Is it news? Is it something else? And we can perform surveys, we can use other tools to try to estimate as best we can the value contribution of the news publishers to the search engine or to a social media site. That's exactly what we're going to try to do at these proceedings. And it will be incumbent on the expert for the news publishers to come up with the best estimate possible. But then Google and Facebook are going to have an opportunity as well. And it's conceivable that at the baseball style arbitration that they would prevail, and the number that would come out of the outcome would be small. So no one should kind of accept this as a guarantee that newspapers are going to win at the proceeding. But I do think that baseball style arbitration will induce both parties to come up with the best estimate possible, because after all, if you come up with an insane or very extreme valuation, if Google puts forward a valuation of 0 for what newspapers are contributing to them, then the arbitrator would be inclined to go with whatever the news publishers have offered.
Thank you. On Friday, another thing we heard from Facebook is that they may just have to cut off access to news publishers in Canada. We saw the same strong-arm tactics in Australia when Australia moved forward with similar legislation. And in fact, Facebook, according to whistleblowers, deliberately cast the net wide. So not only did they shut down Australian news providers, but a whole swath of government and charity websites as well. I'm wondering, in the U.S., as you attack similar legislation, are you seeing similar tactics from the big tech giants?
Oh, yes. Facebook has made similar threats to publishers here. And you know what's ironic about this is that we're arguing that there's a power imbalance, right? That Facebook has monopsony power. And when they behave this way, these bullying tactics, basically threatening to shut down the news, it evinces their power. Who could conceivably talk this way unless they had the power to make these threats? So I feel like they're just digging themselves in a hole and just kind of highlighting the very reason why we're here, the exercise of monopsony power, right, that is depriving news publishers of any positive price of value that they're contributing to these dominant platforms.
Thank you, Mr. Singer. Lisa, that your time is up.
Thank you.
And I now go to the Bloc Québécois. Martin Champoux, Martin, 6 minutes, please.
Merci, Madame.
Thank you, Madam Chair. I'd like to thank the witnesses who are with us today. Mr. Singer, you're all warmed up, so I'd like to keep going with you if that's all right. What you've been studying in the States, can you tell us about the quality of the eligibility of businesses? Can you talk to us about standards for news businesses that can be subject to these regulations?
So I apologize, but I didn't hit the interpret button until the very end of that question. Is it? And now I see it's aimed at me. Is it possible that I could have that back?
Certainement.
I will pause, and I think we can allow Mr. Singer to get interpretation for a question. Thank you.
Madame la Présidente.
Madam Chair, I think I just need to repeat the question.
Pause, Martin, so that you can do so.
Vous avez présentement du côté américain.
So I was asking you, in what you're studying in the States, if you're looking at the quality of content for news businesses, is that something that you take into account and that you're also studying?
Well, in terms of quality, what we're trying to figure out in our studies is we ask people who are on the various platforms, why are they there? What are they consuming? And what brought them there in the first place? I think that quality is going to be picked up in these two different measures when it comes to the allocation phase. So in the first phase, we're trying to figure out how much value is being generated by proxies, like how much time is spent consuming news, what brought them there. And in the second phase, we're trying to allocate according to two measures. One is, at least in the US, the number of traffic that you generate, your pro rata share of traffic, which in part is going to be a measure of quality. But secondly, most importantly, our Congress has set aside 65% of all the proceeds to be allocated in accordance to each news publisher's pro rata share of journalists under their employ. And that is a direct measure of quality, right? So the more journalists that you have under your employ, the bigger share, the bigger slice of the revenue pot that you're going to receive. And so I feel like that's a way to get at this quality issue, is to make sure that the award is allocated in accordance to the number of journalists. After all, at the end of the day, what we're trying to do is breathe life back into journalism industry, journalism. And the way that we do that is by incentivizing the publishers to go back and hire journalists, just as they have in Australia and other places that have received this recent infusion of cash.
Je trouve ça très intéressant comme
I find that very interesting because that was part of our discussions about strengthening eligibility criteria in order to properly encourage high-quality journalism. Do you believe it would be realistic to make intermediaries in a way irresponsible or not responsible for the quality? Because we have heard certain arguments saying that C18 will give privileged status to fake news and to non-credible news content. Do you think it's realistic to believe that there should be a certification added by platforms to news content creators?
I don't think there should be a certification that's created by the platforms. I think that there should be a criteria under which the bill rules out certain participants from enjoying in the proceeds. So that would be the first filter. But the second filter that I'm going to strongly suggest is when we go to the allocation phase, don't make it purely based on clicks, because as you point out, if it were purely based on clicks, then that would tend to feed those websites who don't employ journalists but are very good at generating traffic. What you need to do is you need to make sure that a big slug of the allocation gets awarded to real publishers who employ real journalists. And you do that by looking at how much they're spending on journalists, and that becomes the allocation criteria on the back end.
Je me demande si
I would like to have your expert opinion as an economist and on antitrust matters. In your opinion, regulating an industry, such as regulating the news industry, which operate online, do you believe that this violates the idea of a free internet? Can you tell us about your thoughts on the internet not needing to be regulated? Is it realistic to believe in such a notion?
Okay. This remedy would not affect the free internet, and here's why. Google is not going to suddenly start charging for search, charges consumers for search, because it now has to pay a lump sum transfer to newspapers once a year, right? That lump sum transfer is not going to enter their pricing calculus. And it would completely destroy their business model if they were to say, you know what, instead of making money off advertising, which is the heart of our business and what we've been doing for a decade or more, we're going to start charging for search. They're not going to do that. Same calculus for Facebook. If Facebook has to write a lump sum check once a year that doesn't vary with output, right, it doesn't affect their marginal cost. And so as an economist, as a microeconomist, I can tell you it's not going to change their pricing optimization. And it's certainly not going to cause Facebook to deviate from its model of free social media in return for monetizing the eyeballs and advertising. So I hope this answers your question. Had a few different aspects, but the part that is sticking with me is it going to cause the internet to somehow no longer be free? It is not going to affect the pricing decision of the platforms at all. Search will forever be free. Social media will forever be free, and a lump sum transfer at the end of the year will not affect that.
Merci, intéressante conversation. Merci.
Thank you for the very interesting conversation. That's all for me, Madam Chair. Thank you very much, Martin.
The next question would come from Peter Julian for the New Democratic Party. Peter, 6 minutes, please.
Merci beaucoup, Madame la Présidente.
Thank you very much, Madam Chair.
I'd like to go back to you, Mr. Singer. We've had a variety of witnesses over the last few weeks, the vast majority strongly in favor of C18, including, and I thought this was an interesting point, kind of a watershed moment, the community newspapers of Alberta and Saskatchewan. This is where half of our Conservative caucus is found, and the community newspapers in those provinces are very, very strong advocates for C18, though they want to see improvements in the legislation. And certainly in my community of New Westminster and Burnaby, we've seen a hemorrhaging of local news content as a result of what so many would say is unfair competition. So I'm interested in coming back to the Journalism Competition and Preservation Act in the United States, and wanted you to perhaps tell us a bit about what would happen if this is not put into place. The Australia model is something that a lot of other countries are looking at because their local news, their community news has been decimated. What would happen without the Journalism Competition and Preservation Act? How would you see journalism evolving in the United States?
Yeah, it's possible that the very largest publishers will be able to extract some payments unilaterally, but that's not what the bill is about, and that's not what we're trying to do, right? What we're trying to do is breathe life into journalism writ large, including these community newspapers that you mentioned. There's no way that in a bilateral negotiation between a community newspaper and Google, or between a community newspaper and Facebook, that newspaper is going to be able to extract any payment, right? The payment for access, right, for their content is always going to be zero. So when you think about what the collective is going to create, what this union, if you will, is going to create of newspapers, it is going to lift up the smallest papers, right, in the coalition, right, by leveraging their power, by allowing them to negotiate collectively as one unit, right, against Google and Facebook. Those are the real beneficiaries. And so my critique of what I've seen abroad is that while their heart was in the right place and it's kind of a movement in the right direction, the whole purpose is to lift up the smalls. If you can't do that, really, it's not even worth doing, in my opinion.
And the JCPA would do that. You sense that model will help to enhance local journalism that has been the principal victim of big tech.
That's right. They're going to join the coalition, and they're going to show up as one unit, one cohesive unit at the bargaining table, assuming that we don't reach a voluntary negotiation. I'm very skeptical that we will, but there's a period of time in which a voluntary negotiation takes place. And if that fails, then it moves to binding arbitration. And at that point, they're going to put forward one number, and it's going to be the number of the value contribution by all newspapers collectively for Google and for Facebook, right? And Google and Facebook are going to have their opportunity to knock it down and put forward their own counter studies and their own expert. And the arbitrator will decide whose value is fairest of them all. So a long way of saying, yes, the smaller newspapers are going to benefit because of this design, because we're going to ensure that everyone's coming along. There's no one can be discriminated against based on the kind of content they write or the positions they take. They're all coming along. And at the back end, we're going to have an allocation that is going to be predominantly dictated by the number of journalists that you have under your employ.
So let's talk about the timelines here. You did raise the issue of antitrust legislation going against big tech. You mentioned in your opening remarks 10 years to work through appeals that big tech could bring to stop antitrust legislation. So they have, with their power, the ability to stop up the works for a decade, and I think all of us understand the power that big corporations have. The timelines around the JCPA and around C18, we're currently discussing the thresholds to make sure that this actually goes through, that negotiations are compelled, that there is that arbitration, final offer arbitration, that there is a clear movement. What do you feel are appropriate timelines? Many have said that shorter timelines, 3 months for a negotiated period, then arbitration, final offer arbitration, all taking place in a relatively short span of time, then kind of forces big tech companies to actually work in good faith rather than drawing things out as they certainly would with antitrust legislation. How important is it that there are relatively short timelines around negotiation, arbitration, and final offer arbitration?
I think it's very important. And the reason why is because of the dire straits that newspapers are in. Look, if these guys could make it another couple of years, maybe we could afford to let this roll out for a year, but we don't. And so, what I would see if I could script it, I think each of these breakpoints ought to occur in a span of months. That is, set up a voluntary negotiation period that, give them a month to try to hammer something out. And if they can't, then they move into binding arbitration. Now, when you go into arbitration, you're going to have discovery, and there's going to be, expert reports written. Google is going to get to depose the expert, presumably, before we get into the hearing room. They have to be on notice as to how your valuation methodology is going to work. That could take some time, but I think that should be a matter of months, certainly not a year. I mean, this thing has to get solved yesterday.
Thank you very much, Peter. Your time is up. And now we're going to go to the second round. And the second round is a 5-minute round. And we begin for the Conservatives with Kevin Waugh. Kevin, 5 minutes, please.
Thank you, Madam Chair. I'm sitting here smiling because Mr. Singer has no idea what C18 is all about. It's about the exact opposite he's talking about. The CBC, Rogers, Bell get most of the money. The newspapers get the crumbs. We're not like the United States in this bill, and we have pointed that out on this side numerous times. Small and medium newspapers get absolutely nothing. I'm going to move to Mr. Palmer because you have some recommendations. I sit here laughing at Mr. Singer because he has absolutely no idea what this bill is all about. It's not about the newspaper industry in this country. I've said that for months. They're getting crumbs. I believe the local CBC, the public broadcaster, should be excluded from this bill. Your thoughts, Mr. Palmer?
It isn't so much that I have views as to whether the CBC should be excluded. My principal concerns are with the extremely artificial circumstances under which the proposed negotiations take place. The principal danger is that small and local newspapers or news organizations will be left in the wake of negotiations taking place on the part of the large majors, Postmedia, Globe and Mail, etc., who have enough resources to be able to pay for the kind of expert studies that we're talking about. The second level and third level players in the news business don't have that kind of capacity. That's one of the reasons why this bargaining process favors the large organizations over the small, and I don't think that the bill as crafted will substantially alleviate the situation of community newspapers and regional newspapers.
Well, I think we heard that from Google. They already have 150 agreements, and I'm sure they don't have any agreements from the small or medium newspapers in this country. I think you would agree with that. We've been harping on this side for months that not only Alberta and Saskatchewan, I'm going to say a lot of Ontario newspapers, a lot of Quebec, a lot of the Maritimes, and even BC, where Mr. Julian comes from, a lot of those publishers are excluded from this. And I've got a note here from Cactus, as you know, the Canadian Association of Community Television Users. They're almost going to be excluded from this bill. So there are so many exclusions in this bill that it's going to take days to get the amendments needed to make this bill even half presentable when we do work this thing out. Your thoughts?
I think that that's a serious problem. I think that, for instance, the approach that Mr. Singer is discussing in the United States, where all newspapers, all news organizations are sort of forced into a collective and distributed that way, is a good deal more susceptible of positive outcomes than is the model in C18, where large organizations can put themselves forward, force a collective, an agreement on the news intermediaries, without, however, including the smaller players who have to then try to find experts, lawyers, et cetera, to support a bargaining process. That, I think, is very difficult.
Ms. Gardner, I've got little time, but I am really worried about
45 seconds.
45 seconds, thank you. I have real concerns with journalism in this country. I look at journalism schools, half the amount of enrollment I've seen in the last 5 years, whether it's due to COVID or not, or whether it's due to simply there's no future in journalism. You used to be one. I'd like to ask you about the journalism state in this country as you see it.
Oh, it's appalling. It's terrible. I don't think anybody is arguing differently. I mean, the state of journalism in this country, I had lived outside Canada for 11, I think, years, and I returned about a year and a half ago, and the Globe and Mail is a brochure now, right? Like, I mean, the institutions, even the ones that still exist, are hollowed out versions of their former selves, their memories of what they used to be. Yeah, and that doesn't speak to the local situation, which is worse. There are news deserts now.
Thank you very much, Kevin. Your time is up. And now I'm going to go for the Liberals, I'm going to go to Tim Lewis for 5 minutes. Tim?
Thank you, Madam Chair. I'm going to address all the questions through you. Thank the witnesses for being here. I appreciate it, whether it's in person or online. Maybe I'd start, Mr. Singer, the last round of questions. Address the fact that they believe you don't understand this legislation. I thought it might be only fair you deserve a chance to respond to that.
Well, I think that I am here as an expert on the U.S. legislation, which I helped craft, and so I'm trying to impart some experience and some wisdom that I've learned in the process in the U.S. And so I don't hold myself out as an expert to the Canadian legislation. My understanding is that many of the tactics and the aspects of the bill, a lot has it in common. And I would note on in terms of, we allowed publishers to come in as well, broadcasters to come in as well, although broadcasters in the US don't have the same set of protections as those of newspapers. And I would submit respectively that there is going to be a number that is going to be introduced by the coalition of newspapers. And that number is going to be the value that the newspapers contribute to each platform respectively, regardless of what the publishers put forward, right? So the publishers are going to go after a pot of money based on what they think they're going to be contributing at the margin, and newspapers are going to be, I keep saying publishers, the broadcasters are going to have one pot of money they're going to go after, and the newspapers are going to go after another pot. So I would submit that we shouldn't try to figure out who's going to, which coalition is going to get more relative to the other, but instead what we should figure out is how do we get money into the hands of news publishers, and how is that money allocated fairly, in proportion to the quality of journalism that they're putting forward.
Thank you much. Here in Ontario, we had municipal elections last week. It was a clear example of how important local journalism is. Leading up to the election, our community turned to our journalists for the information on local candidates, important issues, election results. What Canadians want to see is that our local stories are told, and we're simply not defending the newspapers as pieces of paper that are bundled together and tossed on our driveways. We're talking about the legislation that supports the local media outlets themselves. So, Dr. Singer, some have claimed that addressing this market imbalance, which is clear, between the tech giants and media outlets will somehow stifle innovation in the news sector. Can you speak to that claim?
Yeah, I think it would do the opposite, right? If you infuse these local newspapers with cash for the first time for this access fee that would be negotiated, I think the very first thing they're going to do is turn around and invest in journalists. And why we've seen this happen in Australia. But second, they're going to be incentivized. If you do the award correctly, they will be incentivized to grow their jobs in the news business, because doing so will mean that they will get a bigger slice of the pie at the next round of the allocation. So I think they've got private incentives to want to grow output and do quality journalism with an infusion of cash that comes in. But if you get this incentive right, when it comes to the allocation of the award, you can make them even more sensitive to the duty, to this social obligation to go out and hire journalists. That's what we want them to do, and I feel like a smart, intelligent allocation design can get us there.
Well, I appreciate that. And maybe I'll take the flip side. When you testified in the States, you talked about if this legislation didn't happen, the resulting underemployment of journalism. You talked about that can cause less competent local governments, greater spread of partisanship, a greater spread of misinformation, hurting our local economies, and in even reducing the diversity of viewpoints. So can you explain the importance of how we need to get this done quickly because of the consequences of not doing this? What happened with local journalism?
Yeah, in longer pieces that I've written, I've come across a huge literature that shows what happens in communities after they lose their local newspaper. And you've hit on all the things. I mean, employment is the obvious one, but even beyond that, what local newspapers are doing are keeping the community together and binding them, and they create wonders for democracy. There's a whole host of social ills that occur when a town loses its local newspaper. I mean, everything should be done to try to breathe life back into local newspapers. And I feel like the best way to do this, Ms. Gardner talked about a subsidy, that is one way to do it. But to me, if you find the culprit, if you find the person who's sucking out the value, right, and taking it off the backs of the newspapers, it just makes sense that they ought to write a check back for the value that they're appropriating. Why involve taxpayers, right, in what is clearly an appropriation of value from one big buyer, right, away from a small supplier? It doesn't make sense to bring taxpayers into that equation.
I couldn't agree more. Thank you,
Tim. Tim, I think your time is up. And I'm going to go now to Martin Champoux. Martin, for 2.5 minutes, please.
Madame la Présidente, je pense qu'on commence le deuxième tour et vous devez commencer par...
Madam Chair, I think we're starting the second round and you have to start with the Conservatives, I believe.
No, we're in the second round, and after Mr. Lewis will be you, then Mr. Julian, then the Conservatives, then the Liberals. In the
Vous avez bien raison, c'est mon 2 minutes et demie, Madame la Présidente.
Yes, you're absolutely right. I have 2.5 minutes, and I'll take them with pleasure. Thank you very much.
Monsieur Palmer, vous avez des...
Mr. Palmer, a few days ago, you sent this committee a brief, and in that brief, you talked about alternatives to C18, the creation of a fund in particular. There would be a fund that would come from the revenue generated by the companies, and we could use that fund to create a balance in the market. What would be the viability of that fund, according to you, given that we have a government right now that encourages tax evasion and tax havens? Wouldn't it worry you that perhaps the big platforms wouldn't declare the actual revenue that they have, and that could then open the door to unending litigation about the money that should be in the fund?
This is a key question. I think there are a number of actual benefits to a fund as opposed to a regulatory approach. The first one, which will save an immense amount of litigation, is that the raising of revenue is clearly a federal power. It is unclear at all that the federal government has regulatory authority over Google and Facebook. In fact, my opinion would be the contrary. So I think that you're on safer constitutional ground. That avoids, say, 4 years of litigation to get to the Supreme Court of Canada. Secondly, it means that you can bring into the fold all of the groups who are deserving at once. You're not reliant upon, say, the major newspapers or news organizations getting together, going into the bargaining process on their own behalf, and leaving out all the small players who don't have the resources to fully compete in a bargaining process. So I think that a levy or a fund of some kind is actually a very attractive alternative to this kind of process.
En attendant, je veux dire,
So,
le plus rapide des 30 secondes de l'histoire.
it's the fastest 2 minutes and 30 seconds in history. Thank you, Madam Speaker. Or Madam Chair.
Thank you, Martin. And now I go to Peter Julian. Peter, for 2.5 minutes. Thank you.
Thank you very much, Madam Chair. Mr. Singer, I found Mr. Wah's comments somewhat insulting and inappropriate, and I'd like to apologize on behalf of the committee. He needs to be understanding, I think, more importantly, the role that community newspapers play, including in his community, where we've got the Saskatchewan and Alberta Weekly Newspapers Association asking for legislation like this. And I'd like to come back, Mr. Singer, to your comments about community news, because you are absolutely right to identify that one of the reasons we're seeing the rise in hate in all of the toxic forms, more anti-Semitism, more racism, more homophobia and transphobia, more Islamophobia, more misogyny, is in part because those links that community journalists play, community newspapers play, are being exploded as big tech tries to profit from hate. And as you know, in the United States, a major campaign that involves a whole range of organizations fighting back against hate is Stop Hate for Profit. Could you re-emphasize the importance of having a community journalistic sector that helps to counteract how big tech has shamelessly exploited hate to pad its bottom line, so that there is some counterbalance and we can start to reestablish community links in right across North America?
Sure. You know, I blame certainly big tech for a lot of things, but I don't necessarily want to blame them for directly causing this. Let me suggest that the effect might be indirect. In other words, their business model is hurting the local community papers. And when those community papers go down, basically misinformation kind of fills the void, and all the bonds that the community newspapers used to create are now shriveled, and people feel isolated, and they lash out. They no longer feel a connection to their community. So whether or not that's a scheme that, I don't want to suggest that big tech is like scheming that was the end, that was the objective, right? They're not evil, I don't think. But I do think that evil has occurred. And I think that the most important thing now is, rather than trying to kind of, castigate or throw stones, we should just figure out, how do we get money back into the pockets of the local newspapers? And to me, the most efficient route in doing so is to set up a design mechanism in which the two platforms can write a check for the value that they're appropriating. It'll be determined by an arbitrator, and that money should flow back to these community newspapers, and hopefully they can restore all the great things that they did, before they were taken out.
Thank you very much, Mr. Singer. Peter, that's it. And I'm going to go now to the Conservatives again, Mr. Shields, Martin Shields, for 5 minutes, please.
Thank you, Madam Chair. I appreciate the witnesses being here today. Going to, in a sense, weekly newspapers, both in Saskatchewan and Alberta. In particular, I know in my riding, we've got probably a dozen weeklies. They don't belong to that association, in a sense, or agree with that position, because they're owner journalists. They may have one. They don't see the value in this, so they're very clear. So when it's heard that, or said here, that all of Alberta and Saskatchewan, no, they don't have that same view, let me tell you that. They feel they've been excluded. They've been excluded from this. They don't feel they're a part of it. They feel that this piece of legislation is going to kill them, that they'll be gone because there's nothing left for them. So when you talk about negotiations, they can't afford to get in negotiations. They're not part of the organizations. They're negotiations, and the money, as we know, is almost gone. So unintended consequences, Ms. Gardner, the unintended consequences for small weekly papers with an owner journalist, and I have a number of them.
Yeah, absolutely. And I think I would throw in there too the indie publishers and the sort of digital startups, all the little guys, no matter whether they're operating at a local level or not. Originally, the indie startup folks opposed C18, and then I think I think this has happened with a lot of entities. When it became pretty clear that it was likely to go through, I think they shifted their focus to try to tweak it and have some amendments made so that they would be less disadvantaged by it. But they do not want it. And it doesn't surprise me that local news operations, especially those that are explicitly excluded from it because they have fewer than 2 full-time journalist employees, it doesn't surprise me that they wouldn't want it either. I mean, the unintended consequences are, sorry, go ahead.
When you go to more unintended consequences, I would go, let's say, to, for example, when it talks about general. And I was in a newspaper shop when an indigenous paper started in the 1960s, one of the original ones. Are those general? Would the indigenous newspapers, because of their orientation, be left out of this unintended consequences?
Right. I have had those questions myself. And one of the things that we've seen happen, and I think it's so important that this kind of legislation be considered in the context of what is actually happening in the news industry, not just in the context of the news industry needs dollars, right? Because one of the things that has been happening in news is a fragmentation of audiences. And I'll try to keep this brief, but it used to be the case that we all watched the same television news and we all read pretty much the same newspapers. And we all got the same view of the world, and that was good for social cohesion, but it was also exclusionary and marginalizing for lots of different kinds of people, right? They didn't see themselves reflected. And so what we see now is a flowering of many hyper-specific and somewhat specific news operations, aimed at indigenous people, aimed at people who are particularly concerned about climate change, there's a startup aimed at, I think, Asian diaspora in North America, millennials. And so there's a lot of different kinds of operations today, right? And so this legislation should be responsive to that. You could take a number of different views on that. You could decide that it is important that there be general interest publications for social cohesion in the sense of a country as a whole, or you could decide to have a policy objective which follows that trend, right, and supports smaller news operations for distinct identity groups and distinct sort of sets of interests, right? That's the kind of thing that I think you don't get with this bill, but should be considered in anything that is trying to support quality journalism in Canada, because that's part of the question of what is quality journalism.
Right. So the last thing, the baseball arbitrator, the sports arbitration of last, do you see that as part of the CRTC, what they've set up in this legislation, to be anywhere near what a sports final arbitration mechanism is?
You are asking the wrong person. I'm so sorry. Not a sports person. Know nothing about sports arbitration. Sorry.
Go to Mr. Palmer.
38 seconds, Mr. Shields.
Thank you, Madam Chairman. No, it's not like sports arbitration. Sports arbitration is a one on an athlete versus his team. Here we're talking about what is now a partitioned group, various groups of news organizations who may coalesce or may not in approaching the bargaining process. And so the bargaining is going to be very different from final lawful arbitration in baseball, and it's going to exclude, in my view, by design, the very small players who are most in need of a top-up, if you will, at this time.
Thank you.
Thank you,
Madam
Mr.
Chair.
Palmer. Thank you. And I'm going to go to the Liberals for 5 minutes. Chris Biddle.
Madam Chair. Dr. Singer, it seems, looking to the United States, there's also conservative Republicans and very liberal Democrats supporting antitrust efforts to rein in big tech in the United States. I was wondering if you could speak or expand on that a bit, please.
Well, they are. There's legislation in the U.S., the self-preferencing bill, for example, the ban on self-preferencing that made it through the Senate Judiciary Committee, I think 16-6. By the way, the JCPA made it through the Senate Judiciary Committee. It was very popular. I think it was 15-7, getting Republican support as well. I think that Congress recognizes that there are some aspects of the platform's conduct that escapes antitrust scrutiny. And in particular, when you think about what the self-preferencing is doing, it's conduct that's occurring within the firm's boundaries. It doesn't cross a boundary. There's no contract with, say, a supplier or a customer that's exclusionary. And the other thing, too, is that it doesn't generate an immediate short-run price effect. When Amazon, steers search to its own wares in the Amazon store, it typically will replace an independent with something cheaper. So there's no price effect to be found either. These would be horrible fact patterns to go into an antitrust courtroom with, where judges are following case law that's looking for conduct that crosses a firm boundary and conduct that generates an immediate short-run price effect. I would submit that in this newspaper matter as well, it would also make for a horrible fact pattern. No judge is going to recognize scraping, indexing, curation, and appropriation, which is basically just flexing your monopsony muscle, as a cognizable antitrust offense. Certainly not a violation of Section 2 of the Sherman Act. And so I think what Congress recognizes, there are acts of aggression, anti-competitive acts by the platforms that escape antitrust scrutiny. And so rather than try to force everything through an antitrust funnel, we're going to write new laws that get at these acts, these anti-competitive acts, outside of antitrust. That is, to use tools that operate outside of antitrust, as we're doing for the JCPA.
Thank you. There's been recent reporting by Politico on tech giant shady lobbying in the European Union during negotiations on two landmark tech laws. Reports say that tech giants like Google and Meta have deceived lawmakers by lobbying through smaller front organizations, leading EU lawmakers to file 8 complaints to their lobbying body. Someone in Canada remarked that there was so much astroturfing in Ottawa that you'd think we're getting a Major League Baseball franchise. I was wondering if you could speak to some of the tactics employed by dominant tech giants in the United States.
Yeah, so what I see that's so unfortunate is they're not just astroturfing randomly, but they're going after what are traditionally progressive organizations with funding and asking them to come out and oppose or remain silent, but sometimes oppose these bills that would rein in the tech platforms. You know, it's one thing for, say, and I mean this with a bunch of love to libertarians, but it's one thing for like a libertarian front to say there's no market failure here, we don't need government. But it's quite another to have a progressive organization, I won't name names, to come out and say that this bill is is anti-consumer or it's nonsensical, or would open up a floodgate or somehow cause Google to start charging for search. And that's happening. And when those guys say it, when the progressives say it, and they're basically used as as a stalking horse, that's when they can really, when the platforms can really maximize their politicking and their political leverage to try to achieve some wins. And it is, for someone who's kind of not paying attention to where the money is flowing, it can be very confusing. But I feel like a lot of newspaper reporters in the U.S. at least have kind of wised up to where the money is coming and who's buying whom, and they can suss this stuff out.
Thank you so much. And I don't have.
You have 44 seconds, Chris. You can do a thing with it if you wish.
Thank you very much, Madam Chair. We heard one of the witnesses refer to legacy media as and compare it to the buggy whip industry. I was wondering if you'd care to comment on that, Dr. Singer.
25 seconds, Dr. Singer.
I think that what the tactic that Google and Facebook are using here is to try to deflect the harm that they've caused onto some bad technology, right? They're trying to say that this was bad business acumen and they're almost deserving of losing their businesses. But what they're doing is they're deflecting from the value appropriation that they are enjoying in. And so it makes sense that they would put out these buggy analogies.
Thank you very much, Chris, and thank you very much, Dr. Singer. Now, I think I've looked at the clock. We have time for one further full round. And so I'm going to go to the next round, which is Conservatives, Marilyn Gladue. Ms. Gladue, 5 minutes, please.
Thank you, Chair, and thank you to the witnesses for being here today. It's clear to me that C18 is not going to meet its desired goal of helping small local newspapers because, we've excluded anybody that has less than 2 full-time journalists, and it's clear that Bell, CBC, and Rogers are going to get the lion's share of the money. So I'm going to focus my time on amendments that we could make to the bill because the NDP Liberal Coalition is going to force it through, and I want to reduce the harm as much as possible. So to Mr. Palmer, you talked about how we should delete the undue preference part of the bill because it's problematic and that the 52D from Australia would be better. You also mentioned another part of the bill that should be deleted, but I didn't catch that. Could you let me know what that is?
believe I was, sorry, Madam Chair, I believe I was speaking about Section 24, which strips from the digital news intermediaries their ability to rely on copyright law defenses. And I think this is simply a stacking of the decks in a way that distorts and prevents people from actually looking at the value of what Mr. Singer refers to as this appropriation.
Yes, and
if there is an appropriation taking place, the concept should be that to determine it on market value with all of factors taken into place, including common law, at least copyright law and other.
Thank you. And I did appreciate your comments as well about how there's likely to be a constitutional challenge on the DNI definition as it exists. Also, you mentioned that we could improve in the area of defining what is quality journalism. And I liked the recommendation of using the Income Tax Act definitions for journalistic outlets. One of the other ideas that I heard was from Mr. Singer, and it was about how there's a size limit that was an amendment. And so I guess I would ask Mr. Palmer, is there an opportunity for us to do something to limit the size of organizations so that Bell and Rogers and CBC don't get the lion's share and we actually direct that aid where we want it at the local, smaller news media outlets?
Well, there's certainly nothing in the legislation that does that at the moment, and it would require an amendment. Certainly, yes, at the moment, the danger is that the large organizations will scoop all the dough, and there will be nothing left for the minor players.
Indeed. Mr. Singer, could you let us know which portion of the JCPA there was a size limit amendment to and what that amendment was?
What happened in the JCPA, unfortunately, is that large firms were excluded from, large news publishers were excluded from participating in some of the protections. This would be like the New York Times, the Washington Post, maybe the Wall Street Journal. And the rationale was that they are big enough to negotiate their own compensation, thank you very much. But it turns out that even they, as large as they are relative to other newspapers, are atomistic with respect to Google and Facebook. And so in my opinion, this was a mistake in the JCPA. You don't want to exclude the bigs from the negotiation for the same reason that you don't want to exclude, for example, LeBron James from the Players Union. It's possible that LeBron James doesn't benefit as much as some of the rookies or veterans, but just having him in the coalition strengthens the coalition in their dealings against the individual NBA owners. So I understand the politics, but I think if an economist could design it, the big news publishers would have stayed in. So when we go to the negotiation,
I have a limited amount of time. Thank you.
Right,
one more
sorry,
question. No problem. One more question for Mr. Palmer. You talked about how it would be better in terms of determining who it can benefit for the minister to designate it, as in Section 53E from the Australian Act. Can you elaborate on that?
Yes, the Canadian legislation requires a person to self-identify against criteria that is very deficient. It requires that a person come forward and say, I've got an imbalance of bargaining power in my favor. I dominate a market. There's no definition of market. There's no, is this the advertising market? Is this market for eyes and ears? What is it? That's very unclear. It seems to me that it would be far better to have objective criteria and that a governmental official, minister, decide who is and let them fight it if they want to. But I think that'd be cleaner. It would be far more coherent, and it would lead to quicker results.
Very good. Thank you. I think that's the end of my time.
Yes, that is the end of your time. Thank you, Marilyn. I will now go to the Liberals and Mr. Anthony Housefather. Anthony, 5 minutes, please.
Thank you very much, Madam Chair. And I wanted to start with Dr. Singer. I just had the pleasure of being in Congress. We did hearings for our Interparliamentary Task Force on online anti-Semitism. And we got to have hearings where we had Meta and Google and TikTok and Twitter. And I got a chance to talk to a lot of legislators, at least at the House level. And I found real consensus amongst Democrats and Republicans on both sides, whether related to Section 230, whether related to monopoly of the platforms, that there needed to be more done to deal with the practices and techniques of these tech giants. I know that the House of Representatives Antitrust Subcommittee recently accused platforms like Amazon, Apple, Google, and Facebook of abusing their monopoly power. And so I was wondering if you would talk to us about how do these tech giants consolidate their market power, and what practices and techniques are they using that prompt all these concerns?
Well, that's a pretty expansive question, given you're probably aware of all the antitrust litigation that's...
Please, I'm stopping for a second. There is a problem with feedback. I would like those in the room to please mute their mics when they're finished speaking. It would be very helpful. Can we try that again? I've stopped the clock.
Sure. Is this better? Can you hear me now? Fine?
I can hear you now, yes.
Great. So, looking at some kind of common denominator across the various types of conduct that's being challenged, I would say that the fundamental strategy that the platforms have employed is some variation of an anti-steering restraint, or what's called a most favored nations clause. And what this is doing is it ensures that any broker, dealer, say an app developer or say a merchant on Amazon's site, who wants to go off of their platform and sell their wares at a lower price is barred from doing so. And that is, you cannot sell at a lower price outside of the platform, outside of the dominant platform, than you can inside the platform. Google is doing this with anti-steering provisions. Amazon achieves this with the most favored nations clause. And what they're doing is they're making sure that no coalition or individual or coalition of developers or merchants could support a rival platform. If they could steer by offering their consumers lower prices for going off the dominant platform, that could engender a certain amount of multi-homing and competition across the platforms. And that in turn would force Google and Amazon to lower their take rates on the app developers and the merchants respectively. But they figured out that if they can stop that sort of conduct, if they can stop the steering, then they can keep artificially high take rates. And these artificially high take rates, at least with respect to Amazon, have been going up over time, and they all get impounded in the price of everything that you buy. So there's a lot of anti-competitive things that are going on right now, but I know I don't have time to hit them all. But to me, that is the highlight. If you got to attack that, and I do think that squarely falls under the antitrust ambit, and we should give these antitrust cases a little chance to play out on that score.
Thank you very much. That's very helpful. I have a very short question for you. Facebook was here on Friday, and when Facebook was here, of course, they repeated their threat to turn off news content being uploaded by Canadian users, which is what they did in Australia. Have they ever threatened the United States in a similar kind of way, or just small peon countries like Canada and Australia get threatened like this?
No, you don't feel bad. They threaten everyone. They threatened to do bad things in the U.S. too when the bill appeared, when the JCPA appeared to be on its way to getting voted on the Senate Judiciary Committee. But I think that Facebook, whether they want to admit it or not, and Google recognize that newspapers and quality journalism actually prevents their platforms from becoming a cesspool. Imagine if all of this stuff came out, as they're threatening to do, and they take out the quality and they just leave in the low quality or the misinformation, the whole platform becomes a cesspool, and that's going to cause advertisers to leave. That's going to cause users to leave. And so, we should take their threats seriously. But I don't think that at the end of the day, the threats amount to anything. They need the news publishers, but they don't have to pay for it right now because the power imbalance is so shifted in the favor of the platform, right? So what we're asking for is just create a structure so that an arbitrator could make a call as to what the fair market value is right? And then we should go on about our way. Once that payment is made, there's no link tax. Respectfully, Ms. Gardner talked about a link tax. You don't pay extra for each time someone clicks or each link that gets posted. You pay a one-time lump sum fee for access. And after that, you're free to do with the content whatever you want, subject to the applicable copyright law.
I imagine my time's over, Madam Chair.
Yes, 18 seconds, Anthony. Thank you. And now I'm going to go to Martin Champoux. Martin, for 2.5 minutes, please.
Oui, plus les 18 secondes.
Yes, and plus Anthony's 18 seconds that he couldn't use. Thank you, Madam Chair. Mr. Palmer, I'll come back to you. The submission that you sent to the committee last week mentioned the definition of news content being too unclear and broad. Could this be applied to Apple and Spotify and podcasts, and potentially even to app stores, the Google stores, and the like? But you don't mention in your submission how this could apply. And in section 27.1, we see the stipulated which news businesses are eligible. So can you talk to me about these criteria and give me some more details, please?
Welcome that opportunity. As crafted, section 27.1b is the relevant provision. A is a very precise, it follows the Income Tax Act, it incorporates by reference the Income Tax Act definition. B is an entirely different kettle of fish. And so if you had, for instance, a podcast, Joe Rogan, for instance, probably has a good deal more than 2 employees.
Non, mais je vous interromps parce que là, c'est parce que vous dites.
I'd like to interrupt you because you're saying app stores could be considered, could be subject to regulations. And I don't understand. This is what you're saying in your submission?
Monsieur Palmer, vous pourrez peut-être nous fournir cette réponse-là par écrit ultérieurement. Il me reste à peu près 30.
Mr. Palmer, you might perhaps want to give us the answer in writing, and I have 30 seconds left. So we are not in agreement regarding the relevancy of C18. And Ms. Gardner, I'm not disagreeing with questioning the rule of the 2 journalists per small media outlet. So would you be in agreement with putting the emphasis of criteria of journalistic quality rather than the number of journalists employed by an outfit? In a few seconds, please.
Sorry, I'll try to answer it quickly. It's hard to define quality. I think people had talked in previous meetings about standards and practices, right? That there are sort of ways in which journalism organizations adopt standards and practices, and perhaps that is one way to define quality. I just think excluding the very small organizations is a bad idea because sometimes they are the only players and sometimes they play a very, very important role.
Merci pour cette brève.
Thank you for this quick answer.
Martin.
Thank you indeed, Martin.
Now for 2.5 minutes. Thank you.
Thanks, Mr. Singer. I'd like to come back to what we were talking about a few minutes ago. Hate and disinformation. We've seen Elon Musk's takeover of Twitter and deliberate promotion of himself of appalling disinformation around the attack of Speaker Pelosi's husband, and we've had criticisms levied against big tech for their refusal to act promptly to counter disinformation. I wanted to see if you had any comments about that growing disinformation coming from big tech, and also on the other side, which is having responsible journalism. And we have the crazed extremism of Fox News, and we counter that with the kind of a journalistic integrity, for example, that comes from the Canadian Broadcasting Corporation, often opposed by extremists. But to what extent does the JCPA cover public broadcasting like PBS in the United States? And to what extent do you feel it's important that public broadcasting be covered by an approach, for example, like C18, that helps to counterbalance this crazed extremism we see from Fox News and the deliberate disinformation that we're seeing from Elon Musk's Twitter and from other big tech companies that seem to profit from the engagement that comes from this disinformation?
Yeah. I think that what I want to say first is that I'm a defender of big tech's freedom to engage in content moderation, and particularly when it comes to keeping anti-Semitism or inflammatory or violent. How about we could hopefully agree that any comments that incite violence should be under the domain of the platform, and they should have the free rights to restrict and to engage in content moderation. And I don't think that the JCPA at least infringes on their ability to do so. With respect to broadcasters, I think that you have a similar power imbalance where broadcasters are not being paid fair market value. Interestingly, I just point out that broadcasters in the U.S. version of the bill did not want the same protections as the newspapers, and so the bill in the U.S. is written in such a way as to give them some mild protection, but they don't have this binding arbitration, baseball-style arbitration, in which someone could actually compel a negotiation and compel a final payment to be made. That doesn't apply to the broadcasters, at least in the U.S. version.
Thank you very much, Peter. Right on time. And now I'm going to go to the Conservatives for 5 minutes. Ms. Thomas, please.
Madam Speaker, before I start my time, I just would like to ask a question on behalf of the committee. Looking at the clock, I'm just curious as to if you would entertain the idea of finishing this current round of questions and then giving 2.5 minutes to each party to ask subsequent questions.
I was going to put that. I will put that question to you after this round. Thank you. Go ahead, please, Ms. Thomas.
Okay, thank you. What I'm hearing at the table is that I'm hearing from the Liberal members and from Mr. Singer that big tech is bad, therefore big tech should pay, and somehow this equals quality journalism in Canada. That is what is being argued at this table. Ms. Gardner, I'm wondering if you care to comment.
I do agree that a lot has been brought into the room today that is not germane to C18 and is not about news organizations and their relationship with news disseminating platforms. So, I think we all agree, presumably, that there are many reasons to be critical of big tech. And those do include the algorithmic amplification of inflammatory material. And I think that is something that the House is intending to grapple with online harms legislation, right? So that's a really important issue. I'm on the board of the Canadian Anti-Hate Network. That is what we track, right? Anti-Semitism and hate of various kinds, racism in Canada, including what's disseminated by the platform. So it's an important issue. I don't want to diminish or make fun of the importance of the issue. But I do think that I think your instinct is correct. There's a anti-big tech sentiment increasingly, over the past, let's say, 5 years, and it makes big tech a convenient target. And I think that is some of what is happening here, right? Big tech has a lot of money, and I think it's perfectly reasonable to impose taxes upon big tech. And as I said, use that to fund journalism. But personally, I could live without the moral judgment because I don't think it's appropriate.
Ms. Gardner, it seems that if we want quality journalism, then we have to allow for there to be innovation to take place within the news space. Does this legislation facilitate greater creativity and innovation?
Well, the people who are doing the creativity and innovation right now don't think so. And I think that their perspectives are probably correct because they are the folks doing that work. But yeah, from my perspective, this bill will reward organizations that have deal-making capacity, that employ lawyers and biz dev people, and it will reward organizations that have lobbying power and presence in Ottawa. And the little organizations definitionally don't have that. And they spend all of their time trying to innovate their product and sort of tweak it so that people like it more, so that they are more likely to pay a subscription for it or sign up on Patreon or whatever model that organization is using. One thing I can tell you as someone who has run news organizations is the more business models you have, the more complicated your life is, the more masters you have to serve, the more expertise you have to develop. When I was running the Wikimedia Foundation, we experimented with multiple business models for 2 years, and then we doubled down on the one that was working, which was ordinary people giving us donations because they wanted to. It's not, I don't think, a great idea to try to get startups to be in the business of not just pleasing their audiences and aiming presumably for user pay in many circumstances, but also getting good at negotiating with Google and Facebook and coordinating with other entities to do that. And also to get good at government through local journalism funds and whatever other mechanisms the government has. That's another stakeholder and another revenue generation area, right? So that is a lot of complexity for something that is really small when the person doing biz dev, is also writing the news and, maintaining the website. So yeah, I think it will be bad for innovation. And I think innovation is badly needed. What we want ideally is a sustainable journalism industry. And to get there, you have to innovate.
Thank you, Ms. Gardner. Mr. Palmer, comments were made by Mr. Singer around, there seemed to be this claim that there were these two pots of money, which again points to his misunderstanding of this legislation. He pointed to the fact that newspapers are going to be able to apply for money, but then other news outlets will be able to apply for money. That's not the case. Within this bill, there are not two pots of money. There's only one pot of money. And indeed, you will have smaller newspapers competing against larger organizations like Bell. And so we've heard from two different individuals who came before this committee, one representing Alberta newspapers and one representing Saskatchewan weekly newspapers. Alberta newspapers said that within that province, 50% of newspapers would not be eligible because they don't have 2 or more full-time journalists. And then with regards to Saskatchewan, he said that 80% would not be eligible because they do not have 2 or more journalists. If the point of this bill is truly to protect local newspapers, will it accomplish that?
Thank you. I don't think we have time for the answer.
Oh, yeah.
Mrs. Thomas, we have moved on in your time. So now I'm going to go to the Liberals. So for 5 minutes, Lisa Hepner, please.
Thank you, Chair. Mr. Singer, let's pick up on that line of questioning. Can you see anything in Bill C-18 or in your American equivalent, the JCPA, that would stifle innovation in news?
No, nothing would stifle innovation. If you can figure out a way to infuse newsrooms with newfound money, it should do the opposite. It should grow innovation, and it's going to do so by inducing them to invest in journalism.
In fact, would you agree that when you encourage organizations to hire more journalists and you have more journalists on the ground in the newsrooms, in the city halls, in the courtrooms, on the street, talking to people, collecting information, you do end up with more good journalism because you have more journalists going through the training. And I'm sorry, Chair, I'm being interrupted by the member across the table. Maybe she can keep her voice down and whisper.
I'm sorry. Can you please move on, Ms. Hepner? And I would ask people to keep their voice down and be respectful to other speakers and witnesses. Thank you.
So just on that, sir, do you agree that more journalists and the creating an environment to have more journalists working does lead to more good journalism?
Of course, more journalism, more democracy, greater innovation, all good things.
So explain why a funding formula wouldn't be the best way to tackle the market imbalance and the problem, the risk to democracy that we face right now.
Well, I think a funding formula is the best way. It's the most efficient way. I mean, the alternative is what Ms. Gardner was saying, is we should have taxpayers step in and fix the problem that's being caused by the platforms. And I respectfully disagree. If you can calculate the appropriation of value that news publishers are bringing to the table by the platforms, it ought to be incumbent on the platforms to pay that value, what would be paid in a fair market voluntary transaction where absent the power imbalance. So I do think that a structured bargaining with one pot of money for news publishers. Someone said before that I said there was going to be two pots. I was talking about a different pot for broadcasters, but one pot for news publishers. Everyone's in it together is the best way to tackle this problem.
A lot of confusion on the other side of this table. You have
point of order, Madam Chair.
Yes, Mr. Biddle.
Ms. Thomas is again. There's outbursts in the room, which is kind of shocking because she is the first person to jump up and demand respect, but she is the last person to give it to any member of this committee. And it's really become shocking to the point of absurdity that this continues to stand shoulder to shoulder with Facebook and laugh at anyone who would suggest otherwise, Madam Chair. It's truly disgusting.
Thank you, Mr. Biddle. I would kindly ask all members of the committee to be respectful of each other when they're speaking and to be respectful of the witnesses when they're speaking. You will have your turn, and when you have your turn, you can say what you wish. Thank you very much. So carry on, Ms. Heppner. I stopped the clock, by the way.
Thank you, Chair. I would like to continue with your argument that the value of appropriated news content is in its initial instance. So before it's been scraped and indexed and posted and aggregated and displayed. Can you explain this concept to us further?
Right. The question is, what would be paid to the news publishers in a voluntary negotiation absent the power imbalance for access to their content so that Google and Facebook can do all the wonderful things that it does with the content today? What we can do to get at that question is we can see how much value is created on the platform by the news publishers, right? And we can go backwards in time and say, if Google and Facebook would have had to pay for that in a voluntary negotiation, absent the power imbalance, what would they have paid? And they'd pay something approximating the value that is being created. And that's what the fight is going to be about when we get to the arbitration panel, is who can demonstrate credibly the value that's being appropriated by the platforms, created collectively by all news publishers.
Thank you. And just so it's clear for this committee, in your understanding, in Australia, with the implementation of their similar legislation, it was actually the smaller publishers in comparison that did the best, that hired the most journalists, that got the most value. It was the smaller publishers, not the big conglomerates.
I haven't done a comparison of relative hiring, but what I do know, what has been widely reported is that money that was collected by all newspapers, big and small, in Australia, has been invested, plowed back into the investment of journalists. That, to me, is the important takeaway. And, if anyone doubts that that's going to happen, they just need to look at the Australia experience. And if you set the allocation rule right, you're going to create an added incentive to get the news publishers to reinvest in journalists, because it's going to make their allocation, their share of the allocation, bigger on the next go round.
Thank you very much, Lisa. Your time is up. And now I'm going to ask the clerk, what is our hard stop? Can we go an extra 3 minutes or 2 minutes over time?
I actually was not sent the hard stop information today, but lately the hard stop has been the hour, so 1 o'clock would probably be it. I'm seeing that we have about 14 minutes left on the clock, though.
And that's why I ask, because if we went to a suggestion of 2.5 minutes per person and go to a 6-person round, that would give us 15 minutes. So we'd be going 1 minute over time, and I'm sure we can afford to do that. So I shall begin then for the Conservatives. 2.5 minutes, please. Can I have whoever the Conservative person is?
It's Marilyn Gladue. Thank you, Chair.
Marilyn, thank you.
My question is for Mr. Palmer. Do you think that small media organizations will be benefited under C-18?
Actually, no, I don't think so. It's hard to conceive of how the small organizations can coalesce and resource the kind of bargaining process that C18 envisages. That's the principal difficulty with C18, is that in fact it's a partitioned process. The big players can afford to enter into the bargaining process, hire the experts, the lawyers, etc., to support their positions and have it adjudicated. That's not true of, and we don't have the infrastructure in place to support similar efforts on behalf of small independent community newspapers, et cetera, et cetera.
Would it be better then just to have the government, charge Facebook and Google for operating in Canada and to funnel the money into some kind of a fund that's allocated to smaller media organizations?
I think that that's probably a better solution than C18 in terms of being able to get money into the very lowest levels of the journalistic community. The present system, I don't think it ensures that result.
Thank you very much.
You have 1 minute and 9 seconds left.
Oh, excellent. Well, then I'll go to my other question.
Now. Thank you.
You know me, I never
Yes,
give
go
time
ahead.
back.
Go ahead, Marilyn.
All right. Then I would have a question for Ms. Gardner, the same question that I asked to Mr. Palmer. Do you think that small media organizations will be benefited under C18?
No, I don't think so, for the reasons that I said before. I think they just don't have the bargaining power. They don't have the time. They don't have the energy. They aren't big enough to support that kind of negotiation need. And to your second question, I do think, obviously, I have said, I think a fund would be better for that purpose. It's more straightforward.
And so if we get rid of C18 and put a fund in, that would be better. If we keep C18, are there amendments that you would like to see to it?
Yeah, I don't know if I can in the time that you've got, but
could you submit them to the committee, your ideas for amendments to the committee, if you submit them in writing?
Oh, sure. Yeah, I'd be happy to.
Very good.
Thank you, Ms. Gardner. Please do that. And now I'm going to go to Mr. Coteau, Michael, for 2.5 minutes.
Thank you very much, Madam Chair. I want to make a quick observation. We've had witnesses come in to tell us there's been almost 500 organizations that have collapsed over the last decade, media corporations, because of the changing structure of the business in Canada. Also, we've been told, in which I think the Conservatives probably agree, that there is no value to the media that's being distributed on the big tech giants. And I think it's astonishing to just assume that if you open up Facebook or you click a Twitter link or you're on Google, that Canadian content does not have value. If we agree that it has value, then we agree we should assess that value, like Mr. Singer has suggested. It's a very fair process. You actually determine the value of that content on that platform, how much it's being monetized by, and you pay the publisher accordingly. It's a very simple concept. Mr. Singer, just any final statements on reflections of that specific point, or just anything that you'd like to comment on in regard, as we close this session?
Yeah, I want to take on one thing that Ms. Gardner said just a second ago, which is this notion that the smalls aren't going to have the resources to hire up lobbyists to negotiate. And I just want to submit respectfully that when the whole purpose of forming a coalition is that everyone goes in there together, represented by one lawyer, one expert, right? And it's going to be funded as a collective. It's not going to turn on the funding capabilities of any one particular publisher, a small publisher, right? There's no lobbying that needs to take place or negotiation. You just join the collective, and then the collective is going to hire a lawyer and is going to hire an economist. They're going to go into the room and negotiate and try to put forward the best valuation possible. So I want to just dispel that notion that somehow this is being set up in such a way as to make life difficult for the small. It's actually, if it's done right, it should make life easy for the smalls. All they have to do is join the coalition, and then conditional on winning at the hearing, they're going to get their pro rata share based on traffic generation and based on employment. I mean, that's how we're doing it, at least in the United States.
Thank you very much, Michael. I think we've got about 10 seconds left for you. So I would like to move on now to Martin Champoux for 2.5 minutes.
Merci, Madame la Présidente.
Thank you, Madam Chair. Mr. Palmer, I'd like to come back to you. I'd like to hear about legislating companies that do business using online platforms. We've talked about Google and Facebook, but you were talking about all of the internet and easy access for everyone and the possibility for all to benefit from what internet has to offer. But do you think that we should not regulate the commerce done by businesses in general on the web? Or do you object to bills like C18 and C11 in particular? So I'm asking whether your position is general or specific.
No, I think that there is a great deal of work that needs to be done. My concern with C11 and with this legislation is that none of it is taking a comprehensive look at the internet. This is sort of piece by piece. The pieces don't necessarily all fit together. There's not a comprehensive vision on the side of the government that's proposing these various measures.
Mais vous pensez pas que c'est...
But we do have to move forward. Our journalism sector is in crisis. It has been dying over the years. Don't you think that this is a first step and that we can and will improve the legislation over the years? And we'll see what the problems are. Don't you think it's already a good step in the right direction?
I think it's a good first step. I think it's a bad first step, and it'll be a fatal first step for a lot of journalistic organizations, news organizations. And that's my concern about this. The American model that is being suggested is to bring together a coalition of everybody that's in the news business. C18 doesn't do that. It allows for a partition between big players and small players. There's nothing that forces them into a collective. And without that, you're going to get a lot of losers.
Mais c'est effectivement quelque chose qui peut être corrigé par le biais d'amendements.
But that's something that can be corrected through amendments or over the coming years, don't you think?
But you'd have to reshape it significantly to do that. I would be all in favor of something that would, in fact, force this kind of coalition that the Americans are looking at. I think that would be a very positive step.
Merci, M. Palmer. C'est tout, Madame
Thank you very much.
Thank you very much. That's all for me. Thank you.
Now go to Peter Julian for 2.5 minutes, Peter.
Thanks very much, Madam Chair. Just coming back to you, Mr. Singer, I asked specifically about public broadcasters and to what extent there is provision for them in JCPA. Of course, that's the PBS broadcasting systems in the United States. Your answer about broadcasters generally was that they are exempt from some provisions of the Act, but is there any particular attention given to the PBS broadcasting systems, both radio and television?
I don't think PBS gets any special treatment under the bill. I think that what happens is the broadcasters sought and secured good faith negotiations, but it ends there. And I think that they have some recourse if the counterparty is not acting in good faith, but there's no kind of back end binding arbitration that the newspaper coalition is going to enjoy.
Okay, thank you. That helps to clarify. Thanks very much. Now, coming back to this issue, and of course, we're considering amendments. So I'm a bit perplexed about some members around the committee that seem to say, let's throw the whole bill out because there's some amendments that need to be brought. It's obvious that the bill can be improved. And one component is around particularly small community endeavors, owner-operator newspapers, which is often the case, or broadcasting entities, community radio, is often the case in smaller communities. Can you speak to the importance of this approach that we saw in Australia with Country Press Australia representing about 150 small community newspapers across Australia, getting that important provision for funding that helped to revitalize the sector, and the importance of ensuring that small small community papers are included, and that must mean considering some amendments to C18.
I think that the small communities obviously did better as a coalition than they would have done had they negotiated individually, right? And they did better. They actually secured money, and we get to see what they're doing with that money now. But my thesis, I'm going to stick with it, is that they would have done even better had they been able to negotiate as a collective with all newspapers, including the large. That is, I don't see a good economic rationale in splitting off the smalls and telling them, you guys go negotiate as a collective. Yes, it's better than individually, but if I could structure it, it would be everyone negotiating as one news publisher coalition.
Thank you very much. That's it, Peter. And I think, given that we do not have any extra minutes to use in this committee this morning, we have 1 minute left to go, and I'm going to use that 1 minute to thank the witnesses for coming and being asked hard questions. I think that it was a very respectful meeting in my point of view, and I want to thank you for taking the time to come and helping us. And as many members have said, hopefully out of your testimony there can be amendments found to the bill. And so I want to thank you all, and I now move that this meeting be adjourned. Thank you.
Thank you.